What's your instinct as an attorney about the defendant's credibility?
Ashley, I think Kit Martin presents very well. I mean, he was former military, decorated veteran, obviously commercial airline pilot, and even the court martial, the most serious charges were ultimately dismissed. He was convicted of the misdemeanor assault and the downloading the classified materials that kill list. So I think he's going to present very well. I don't know if the defense is going to put him on the stand. They probably don't need to in this case. Going back to some of the evidence that he discussed, which is the surveillance and so forth. One really important point that came out this week by the prosecution is obviously there's surveillance of the back door, and you see Martin going out there shortly before midnight for a few minutes. But there's no surveillance or any video of the front door. And both Martin's fiance and the two children said that door was inoperable, couldn't be opened. But you really had law enforcement come in and I think successfully rebut that testimony and show, well, no, this door was actually locked and at a doorstop, but it certainly could have been opened and Martin could have exited out of that front door had he wanted to do something that wasn't caught on camera.
All right, tell us a little bit more. I do note that you just said that you don't think the defendant needs to testify in this case. Tell us, if you were his defense attorney, why would you suggest that he not testify?
When criminal defendants testify, really the whole entire defense really comes down to their testimony. And, Martin may testify and may testify well, but I don't think he needs to in this case because, you have those alibi witnesses. Obviously, they're family members, but I thought that they did testify well. I expect that their cell phone expert, by their, I mean the defense, will testify that, Martin's cell site evidence shows that he was actually home the night of the murders and, during that time period. If you have that, I think that's enough reasonable doubt. I don't think you need to roll the dice by putting your client on the stand, have him testify. Now, if they don't have that cell phone evidence and they need something to get over the hump, Kit Martin may testify. But again, I just don't think it's necessary in this case, given the state of the evidence presented by the prosecution so far.
And that reasonable doubt, I want to take this opportunity because you just opened the door to a really good conversation piece, and that is shifting gears to talk a little bit about the charges against Martin, because he is accused of acting alone or in complicity with others to murder. And that's what the charges are involving the victims in this case, Calvin and Pamela Phillips, as well as Edward Donsereau in November of 2015. Martin was indicted on 3 counts of complicity murder, 2 counts of complicity burglary, 1 count of complicity arson, and 1 count of attempted arson, plus also the 3 counts of complicity tampering with evidence. An investigator told the grand jury Martin was charged with complicity because the state cannot prove for certain that Martin himself carried out the crimes. But the investigators, obviously with these charges, felt confident that he did take part in these acts. Now, in Kentucky, liability for complicity requires the state prove the defendant solicits, commands, or engages in a conspiracy with such other person to commit the offense, or in the alternative, aids, counsels,